Dear colleagues, it is 6 o'clock and we should proceed. Good afternoon, dear colleagues and guests. Today, February 11th, 2021, 6 p.m. Moscow time, led the meeting of the Dissertation Council for the defense of the thesis of Mikoni, Tatiana, Sergeevna on scientific degree of the candidate of Judicial Sciences on Speciality 120003, Civic Law, Business Law, Family Law, International Private Law, protection of the bank client's rights in the transaction with the use of payment cards, be considered open. Order of the Academic Secretary of St. Petersburg State University, Gnotov, from the 7th of December 2020, number 110229. I, Petrov Dmitry, Doctor of Legal Sciences, Associate Professor of Commercial Law of St. Petersburg State University, was appointed Chairman of the Dissertation Council. Let me introduce the members of the Dissertation Council. In the remote access mode, we have the following members: Gordov Oleg, PhD, Legal Scientist, Professor of the Department of Commercial Law, St. Petersburg State University. Can you see and hear us? Great. Vovendopoulos Vladimir, PhD of Legal Sciences, Professor of the Department of Commercial Law, St. Petersburg State University. Can you hear and see us? Vladimir Fedorovich is the head of the department of St. Petersburg State University. Ludmila Efimova, PhD of Legal Sciences, Professor, head of the Department of Banking Law, Moscow State University, named after Kutofin. Can you see and hear us? Yes. Anatoly Kostruba, PhD of Legal Sciences, Prigopasha National University, name of Vasily Stefanik. Can you hear it, see us? Thank you. And the applicant, Mikoni Tatiana, is present here. She's behind the rostrum, you can see her. Also the academic advisor, Natalia Raskazova, PhD Legal Sciences, Associate Professor, St. Petersburg Notaries State University. Also, there is direct online broadcast on the website of St. Petersburg State University, and simultaneous interpretation is provided. Dear colleagues, I have to announce the technical break number 1, a 1-minute technical break. I need to specify 1 point. So, technical break. The technical break is effective. I'm sorry for this break. I needed to clarify 1 point. So the technical break number 1 is over. So we continue our meeting. Currently, there is an email address posted online using which all the listeners can express their opinions and send questions online to the applicant concerning the thesis and the scientific discussion of the speech. These questions will be forwarded to me by the technical service, and I'll voice them during the discussion. Questions should be related to the performance of the applicant and the content of the thesis. It is obligatory to indicate name, surname and middle name, position and place of work of the author of the question. Questions not related to the scientific discussion, to the thesis and to the text of the thesis will not be voiced. In accordance with the procedure for awarding the academic degree of Candidate in Sciences and academic degree of Doctor of Science at Petersburg State University, approved by local regulations in Petersburg State University, hereinafter the procedure, the meeting of the State Council is considered competent if at least 2/3 of the approved composition takes place in the work, not less than 4 people. Our Dissertation board consists of 5 people. All 5 are present, including 4 members of the board in a remote online mode. All members of the Dissertation Council and the applicant are provided with audiovisual contact. Thus, there is a quorum. I establish the following rules of procedure for today's meeting of the Dissertation Council of a total duration of approximately 2 hours. First, a brief report of the chairman on the documents submitted by the applicant for a scientific degree and their compliance with the established requirements. Answer to possible questions, about 5 minutes. A short presentation by the applicant for the scientific degree reflecting the main points of the research. 15 minutes. Questions to the applicant in strict accordance to the report, no more than 2 minutes per question. Answers of the applicant to the questions, no more than 5 minutes altogether. Reviews of all the members of the Dissertation Council in turn, with the assessment of the thesis and the presentation of the applicant, with summary of the position, questions and suggestion for the applicant. Approximately 10 minutes per speaker. Speech by the chairman with the assessment of the thesis. Answers of the applicant for the scientific degree to the questions and comments of the members of the Dissertation Council, no more than 2 minutes. Open discussion. Speeches at the request of those present at the defense of the dissertation, with the summary of the position or with specific questions or proposal for the applicant based on the topic of the research, no more than 2 minutes per person. At the same time, we ask everyone to register in the registration form if you are willing to ask a question and to introduce themselves before having the floor. Next, presentation by the chairman of question addressed to the applicant, which came in order to discuss the presentation and the thesis via the website of St. Petersburg State University. I'd like to draw your attention the written questions, which take more than 2 minutes to be voiced, will not be read. Applicant's answer is no more than 2 minutes per minute. Presentation by the supervisor of the applicant no more than 3 minutes. Discussion by the members of the Dissertation Council before the open vote of the results of the defense, during which the broadcast line is muted for about 5 minutes. Open roll call, vote counting, with the entry of the result into the minutes of the meeting. Next, making decision whether or not to award the academic degree, and the final word of the applicant, no more than 2 minutes. Dear colleagues, are there any questions or objections to these regulations? Great. If there are no objections, I'll proceed to the implementation of the rules of procedure. First of all, please turn up the sound of your mobile phone. And I would like to ask our colleagues in the remote access mode, I ask you not to turn off your mobile phones, but to turn off only the sound, so that we can have a way to contact you in case of technical problems. So we start the meeting, and the first is the chairman's brief report. The thesis of Tatiana Mikoni for the degree of the candidate of Legal Sciences, the Criminal Code Scientific Speciality, 12003, Civil Law, Business Law, Family Law, International Private Law, protection of the bank client's right in transaction with the use of payment cards, was accepted for defense by the order of the Academic Secretary of St. Petersburg University from the 26th of November 2020, number 10770/1. Tatiana Mikoni wrote the thesis and conducted research at the Petersburg State University. Its scientific advisor is the candidate of legal sciences, Raskazova Natalia, head of notary office in Petersburg City University. The number of publications of the applicant set on the basic scientific results of the dissertation amount to 3 in peer-reviewed magazines and approved by the Ministry of Education, 2 in the Scientific Basis website, and the scope is 1. The applicants submitted to the Academic Secretary of St. Petersburg State University Alexander Gnotov a complete package of documents for acceptance, for consideration, and defense of the thesis. All documents correspond to the clause 12 of section 3 of the procedure. All the applicant documents, based on the information I received from the curator, meet the requirements and are kept in form of copies in the attestation document pack. Before giving the floor to the applicant, are there any dear members of the Dissertation Council, any general question to the applicant? There is a need to announce and consider the entire list of documents submitted by the applicants for defense. Yes? No? There are no questions. Then the next stage is a brief report of the applicant. Tatiana Sergeevna will give you the floor. Good afternoon, dear Chair of the Dissertation Council, all the members of the Dissertation Council, everybody present or anyone in remote mode. Payments using payment cards are of great interest for scientific research, since the widespread of non-cash payments is growing every day. However, the study is not accidentally called the protection of the rights of its customers when using payment cards. The main goal was to consider the peculiarity of legal status of the bank client as a weak side in relation with the bank, and to determine the most effective way to protect the client's rights. In this sphere of financial service, there are always professional and information asymmetries between credit institution and the client. The bank is a professional, client is not professional, especially when we talk about the client as a physical entity. Such disparity predetermines the need for the state to participate and protect the weak side. But is there a need of such a protection in loan sphere? In the payment section, there is no unified system of protection of the rights of bank clients when conducting transaction with the use of payment cards. The object of the study was to determine the analysis of the legal relationship between the bank and the client, to determine the cases when the limitations in the agreements are necessary, and how this limitation should be put into force in order to protect the clients. Thus, the object of the study was the legal relationship between the owner of the payment cards and the loan institution. The study of legal relations is the study of social relations in their legal form. The subject of the study is the norm of legal acts, so the rules governing the social relationship. The main conclusions include payment card is legitimate paper or sign. It serves as evidence that the holder has a right from the agreement concluded with the bank. The payment card proves the existence of such a right. The bearer of the card is presumed as an entity empowered to give orders to the transfer of funds to the bank. The bank, in case of following this order, will be the party fulfilled its obligations under agreement, even if it turned out that the other person who is not unauthorized exercised this right. Since, unlike a share or security, the loss of the card does not lead to the loss of the rights of the cardholder. The proof of which is only changes to the procedure for exercising the rights. For example, without a payment card, a person cannot pay in a trade organization or withdraw funds from an ATM. But if the bank has the ability to verify the authority of the person in the absence of the card, there is no reason to reject the client's right to dispose of funds. The bank may refuse to carry out an operation on the account without a card, only if the agreement expressly provides for a corresponding restriction, and then it should not be a burdensome limitation to the client. The example is when the bank rejects conducting the settlement, although the bank has all the necessary opportunities to check the identity. Payment cards have a number of features. Nevertheless, they cannot be considered an independent form of payment. All these characteristics should be taken into account during the payer's bank debits, beneficiary's bank credit funds, and other types of settlements. And there are certain money transfer regulations within the monetary system. Regardless of the form in which the settlement is carried out, special rules established by the Bank of Russia are applied to all payments using payment cards. When we talk about settlements, we should pay specific attention to the termination of the monetary obligation between the card holder and the recipient of the monetary funds. When payment card is used, the rule is valid when the money is sent to the emittent bank or the acquirer's bank. It acts unless otherwise provided by the law or the agreement of the parties. In particular, the law on consumer protection provides for special rules for settlements with participation of consumer. The consumer is considered to have fulfilled the obligation to pay at the time of delivery to him of a message about authorization of the operation or about debiting funds from the account. The lega ferenda is necessary to provide special regulation in the event that the cardholder, despite the presence of a properly drawn up order for transfer of funds, is forced to fulfill the monetary obligation again. Such a situation might occur when a cardholder sent the money during some period of technical problem. In this case, the card owner may revoke the money transfer, addressing the bank, providing proof that the settlement had already been met. Let's move to the characteristics of the agreement of the issue and use of payment card or a debit card. It's possible to use debit card in order to do different transfers within the bank account. So the client and the bank sign an agreement, and the client gets the debit card as a thing proving the opportunity of money transfer. The bank doesn't find such a rule mandatory, but there is one exception. The emission of the mirror card for a specific group of citizens who are paid through the budget of the state of the Russian Federation. Thus, the limitation of the rights of the client is determined by the legal causes, so as to provide the development of the national systems of payment card. The use of the card as the way to enforce the document, the agreement, provides for the following. The bank and the client, there might also have a third person participating. this third party is not the party of the agreement, but it's necessary to determine its legal position. The holder of the additional card might use the monetary funds as the representative of the client or the third person at the request of whom the bank has to follow the requirements of the client. The second option is more preferable from theoretical and practical point of view, since it responds to the type of relationship between the client and the third party. It provides for the opportunity of card emission for minors. One of the main reasons of violating the interests of bank clients is the existence of information asymmetry between the bank and the client. Thus, when conducting this study, special attention was paid to the bank's obligation to disclose information at the stage before the conclusion of the agreement as within the conclusion of the agreement. To protect the rights of the client is important, but it's of prior importance to provide the client the comprehensive information about the purchase service so that the client could have a reasonable approach to purchasing an item or service. Three main conditions for the effectiveness of information can be formulated. Information should be sufficient but not excessive. Secondly, information must be understandable. Then the information must be provided to the client in advance. Thus, the client will be able to use it to practice further service. The bank provides the client enough information. But this is not enough to say that the bank has met its obligation to inform the client about the terms and use of payment card. So publication of the rules on the website is not enough to say that the bank complied with the pre-treaty agreement. Only if the client got the information in such a way as to understand it and take it into account when considering drafting the agreement and enforcing the agreement. After the agreement is signed, the most important aspect is the monetary fund. Many clothes from the European system have additional pockets where additional things might be kept. The procedure of notification should be determined by the agreement between the client and the bank. If the client didn't choose a specific way of notification, then the bank does not have the right of choosing whatever the bank wants. The bank should choose the way according to which the client gets to know the bank as quick as possible. Choosing a different type of informing, which doesn't give the client the opportunity to use in the voluntary gathering of information, and is a rather totalitarian one. The last issue is the distribution of the expenses between the client and the banks. When using a payment card, there is the risk of doing unauthorized transactions. Because of the legal actions of third parties, money funds might be withdrawn from the account, and the expenses might be distributed by the bank on either principle of reduction of losses or assigning losses. There should be several options to localize these issues, which is provided by the mechanism of the responsibility of civil law. If the bank violated the law which led to this sanctified operation, if the client violated the rules which led to scientific situation, when neither the bank nor the client are responsible for the losses, the mechanism which helps to identicate who is to be eligible. This is the mechanism of risk estimation. Firstly, the first option is when the expenses remain in the bank, second, when expenses are paid by the client, and third, when expenses are paid both by the bank and the client. According to general procedures and rules, the risk is provided to those who might minimize the risk or effectively use it. And minimizing the risk means decreasing the cost of the risk and minimizing the possibility of such an event in the future. Thus, cutting expenses depends on the efficient distribution. So the first is the distribution expenses strategy. So the excessive payment are allocated to the party which might shoulder the situation. Next is the second group, which can provide for their expenses with less difficulties. And the process of legalization of the expenses must be as cheap as possible. Considering the relationship between the bank and the client, several summaries might be made. The bank can always reach the neutral attitude to the risk if compared to the clients. Thus, according to the principle of allocating the expenses, well, the bank has to be held to be responsible. If we talk about the expenses which happened before the bank found out or had to find out about the risk of non-sanctioned use of the payment card, in here both the client and the participant and the bank might take necessary steps. With the necessary information, the bank might have next steps to prevent the expenses. Since first the principles demonstrate that depending on different situations, the client should be held responsible for the injuries, or the banks should be held responsible for the injuries. A mechanism should be created to provide maximum efficiency to switch them from the private estate to the work of an individual. The national payment system law shows that neither effective allocation of expenses nor just allocation of expenses is provided according to which. Since norm is based on the erroneous assumption that expenses are originated in the hands of the clients, which is not true. First of all, the bank should be held accountable for an unsanctioned operation. All the expenses should be paid or covered by the client, not only when the client, but also the bank might decrease the possibility of occurrence of such expenses. The opportunities of the client are rather limited if we talk about the respective expenses. So the client should not be faced with excessive risks, because it might result in the situation when the client does not use payment cards. All the other expenses should be covered by the bank, because it will lead to the increase of the safety of settlements. Otherwise, the bank might be interested in creating more sophisticated rules of payment cards and not in improving the quality of transaction using debit card. And the bank is relieved from the necessity to compensate the expenses to the client when it itself could influence the situation. The bank has to compensate the expenses from a non-sanctionized operation if the bank did not announce the information to the client in advance. Nowadays, the bank has to give information based on the last authorized name or number of the conference. All the expenses on non-sanctioned operations and non-sanctioned operations should be posted, and this way people wouldn't have been caught once again. There is a national payment system which might provide economically efficient risk distribution between bank and clients. Thank you very much. That's it. Natalia Sergeevna, thank you very much for your presentation. Are there any questions to the applicant based on the report? No? No questions to the report? Well, I see there are none. Then we move on to the second stage of our work, which involves the reviews of all the members of the Dissertation Council in a row with the assessment of the dissertation research and the presentation of the applicant. I'd offer all the members of the Council to voice their reviews, voice your recommendation and questions. Then Tatiana Sergeevna will provide a general answer to all the comments and suggestions, so that we have a good understanding of the situation. Since all the reviews were published on St. Petersburg State University website, then I ask the members of the Council to read and to state only the key points, the questions and remarks to the applicant. Nobody's against? Thank you. So we move on to the reviews to the members of the Dissertation Council. Gordov Oleg, the floor is yours. Dmitry Anatolievich, thank you very much. As you have recommended, I'm not going to talk about the novelty of the topic and relevance of the topic and the good results that were provided by the applicant. Well, the work is positive and the author managed to achieve the goals set in the work, and we all were able to see quite logical scientific approach and good recommendations. Since the work is the result of creative activity, it does not have any discussion ideas and discursive author's perceptions. So there are no discussion perception in the topic. So first of all, it is necessary to provide additional information on the stance of the author, which could be seen in the name of the third paragraph, chapter 1, according to which its legal nature. Each entity is the subject of the civil law, and the author came to this conclusion through a series of logical ideas, and the trajectory of the discussion came through the such ideas as digital payment system, a payment instrument, a good provided documented securities, judicial document. And the author finally says that payment card is legitimation paper. As we know, among the members of the according to the civil law, these are securities, the number of which is stable, and they cannot be included into the types of papers used by the author. If we look at the thesis, the author uses civilian adjectives, which is not quite right for the field of non-cash monetary transfers and cannot be associated with legal regimes. So the same information of objects of civil rights are currently not attributed by the legislature. Information itself, the civil rights information, is not part of the civil rights. So this is my comment, which requires additional commentary from the author. Second, When analyzing the legal nature of emission agreement and using payment card, paragraph 1, chapter 3, the author does not appear to have written ambiguous answer to the answer of what the subject of the specific contact and the essential condition of the letter. And the third remark, clause 4 of the provision submitted for the defense is according to which, when making payments using credit card, the obligation under allying circumstances is determined by proper performance, that is, by payment. The moment of fulfillment of the monetary obligation is crediting funds to the corresponding default lender's bank. Opening the settlement center of payment system within which the situation calculation is carried out. This rule applies and is provided by the law as an agreement of the parties that demand no transaction. Maybe it's not new, but it should be talked about. These are three comments of discussion matter, but they do not negate the overall positive overview of the dissertation. So the thesis corresponds to the main requirements established by the order of 9th of January 2016, number 6821/1, in order to award an academic degree in Specialisation University. The applicant Mikoni is Tatiana deserve the academic degree of Quantitative Legal Sciences. Protection of the bank's civil rights in their transaction with the use of payment cards complies with the requirements in accordance with the Ordinance 6878/1 on Mikoni Tatiana Sergeevna deserves being awarded the degree of the candidate of legal sciences. So 11 out of 12, the dissertation provision was not violated. Thank you very much for giving your opinion. Vladimir Papandopoulou, please. I would like to ask you to voice your view based on Mikoni work. Thank you very much, Dmitry Anatolyevich. I'd like to be very brief. I'd like to note that the topic is of high relevance, at least based on the fact that the respective relationship have been in place for quite a long time. There is a national payment system. Governmental decisions are being taken. Its practice is being discussed, and literature discusses such problems. So there is a comprehensive approach to this situation, and I do hope that we will be able. So we will be able to develop this topic, and as it seems to me, Tatiana Sergeevna managed to perform her work efficiently. She provides some theoretic background, but mostly it has a lot of practical oriented background, which is of crucial importance. I'd like to say that in all the chapters there is, not only in the chapter, the introduction and the outcomes, there is the right summary at the end of each chapter. Well, since I do not like such a format of taking the floor, I wouldn't like to speak too much on the issue. I would like just to note that such positive sides are existent. As for remarks, in here the situation is the following. I have some formal remarks aimed at the formulas used to formulating such words as legal, forming. The thing is that not the scientists, the novelty is not as explicitly described as we would like to. So there is no information what has been viewed in which respect. Sometimes specific details might be lacking. And a part which is of importance to the thesis, which can be present as defined in the introductory part. So there are some formal remarks. I'm not going to ponder upon them. You might read them. And I would like to say a few words about the remarks concerning the content. And also I would like to note that these comments will be not aimed at the thesis as a whole, which is aimed to the protection of the rights of clients. But the comments will be linked to the risk location between the bank clients and the banks themselves. I will also like to pay attention to related to the nature of the relationship and the subsequent agreement. So these are other remarks, not even comments or questions. But maybe Tatiana Sergeevna will say that I'm wrong in this area. So my first remark is the following. Linked to the origin of the card. The author says that the relationship with the card is that of ownership based on a deal. But at the same time, in chapter 3, the author talks about the agreement of emission of the pay card, which is a mixed agreement which has different elements, including the number of the account and so on. So if a credit card is like a thing, is passed by the bank to the client, why after the expiration date it doesn't have to come back to the bank which owned it? We can consider that from the point of view of legal regulation, defining the card as a thing and the possibility of possessing this thing has no legal power. As a thing, what is the difference? The thing, from the point of view of its rent, sale, bail, is not of interest from the judicial point of view. As a legitimation sign showing the rights of the client based on the agreement with the bank to control the amount on the account. The owner might be able to give the card to a different person, and the bank should not even be notified. Might there be a formal ban, formal prohibition? There are certain bans, and they have only the meaning that the official takes all the risks. We might not pay attention to the inaccuracy of the theory if the conclusion on the type of the relationship between the card holder and the emittent. And this is my second remark. Not agreeing with the well-known approaches to the definition of the nature of emission and the use of payment cards, and considering the payment card a thing, it leads to the fact that a card is used as a digital option of the payment, is only an agreement construct and not a type of agreement, based on the card emission, is temporary, which has the information considering the bank account and has the information considering providing access and ownership of an object. Third, these not highly convincing conclusions are at odds with other conclusions which are more specifically proved. That is, the payment with the use of the debit cards is not an independent form of settlement. Nevertheless, they have certain peculiarities and they determine the structure of agreement relationship with settlement. So in here, the author doesn't say about the card as a thesis. So I'll be ending my speech right here. So these points form the base of the scientific discussion and are the result of labor and participation. And all these remarks do not undermine the positive effect of the thesis, and it has a high practical influence. So I would like to say that the thesis by Tatiana Mikoni, protection of the bank's client's right in the transaction with the use of payment card, corresponds to the main requirement according to the procedure of awarding the degrees of the candidates of sciences in Petersburg State University, and the applicant herself deserves being awarded the degree of the candidate of legal sciences in specialty 12003, civil business, family and international private law. And the Article 12 is not violated. Thank you very much for your positive review. Now we give the floor to Ludmila Yefimova. Thank you very much for giving me the floor. I'm not going to talk about the general information. I would like to say that I like the thesis by the applicant. Something might be discussed, and the work overall is highly positive. Of course, any work, any thesis has certain comments and reviews, because, well, none of the works might be left without any remarks. So I would talk about the main remarks that I have. So the first remark coincides, and I'm not going to voice it in full, with the remark by Oleg Gordov. And I think that the provision number 4 is not a novel one, because it talks about the norm which can be found in the Article 17 of the law number 161 FZ, the payments of monetary obligation to the recipient of funds. Maybe it doesn't have a direct reference to that, but we might get this decision through the context. Pages 28 and 30 of the thesis, the author reduces all the legal features of the payment bank card only to the performance of the identification function. Well, the author also writes that this is a thing, but the thing might be used differently. Well, if we talk about the functional approach, we should determine for the origin of the payment card why we need the banking card and how is it used. So this is the functional approach with the consequent summary of the nature of the card. So the author says that the payment bank card means identifying its owner. There are not all the functions performed by the payment instrument. Payment bank card is multifunctional technical device. It can perform several functions without the need of the card holder to fill in all payment details that are already fixed by the technical means. Then the author says that is a means of access to bank account or way to obtain bank loan. And the summary is correct, but is incomplete because other forms are not mentioned. Well, the payment bank card is a way of identification of the owner, but this is not limited to that. It is a multifunctional technical device which can and produces several functions within the transaction of non-cash payments. The payment card, any payment card, the debit card, a credit card, or prepaid card, even the credit or loan card, is the way of creating the settlement documents in a facilitated way. The card is usually aimed at private entities and is very difficult for owners to insert the information on the bank accounts and the corresponding account. These are loan accounts figures, and if a person is filling this information on their own, then there might be certain mistakes. And if a bank card is used, then all the necessary information is already imprinted in the card. So the bank account is already specified and all the information of the payer. With the help of the payment card, when using the ATM, for example, the data is read from the bank card and is included in the digital payment document. This is the most important aspect of the payment card. If we talk about legal entities, then they have an accountant which might be responsible for inserting the necessary information. So it's important to pay attention to private individuals. Then a payment card is a way of distance settlement. And in accordance with the law of 161, we consider the bank card as a way of digital function of the payment. Then the payment card is the way to access to the account. This is a debit card, which is said by Mikoni, Tatiana, or a way of obtaining a loan if it is a credit card, or it is a way to manage electronic funds if we talk about prepaid cards. To summarize all the above mentions, bank card can be considered a way of concluding an agreement. Fourthly, the bank card performs a legitimizing function and is a means of identification of the client of the issuing bank, more precisely a means of simplified identification. If we think about the Federal Law 115 AZ, is the bank card an identity document? According to the author, is an interesting issue. It might be a document, but this is a controversial issue, and this issue has to be discussed at the defense. It is quite obvious that a bank card, when used, creates a presumption that the entity apply the settlement document with its help is most likely a client of the issuing bank, since the PIN code was typed correctly. No matter how many functions the card performs, it still remains an instrument of non-cash payments, since all the above-mentioned functions are subordinated to the solution of only this task. In other words, a bank card always remains an electronic means of payment. So I'd like to ask the candidate, the applicant, Tatiana Mikoni, to specify the idea on the functions of the bank card in the process of the defense, taking into account my remarks. Well, this is not the objects of civil law, of course. This is definitely the means of electronic means of payment. The third remark. On page 27 of the thesis, since the payment card contains information, it can be identified and intended for transmission in time and space, it is a document. Well, this is, in my opinion, a very interesting conclusion based by the author, but it remained incomplete. So, it has to be specified which document that is. So this conclusion is supported by us, that this is incomplete for the complete characteristics of the specific traits of the bank card. Document is not kind of information which is chaotically set on the bearer. The information has to be structured, and the mechanism has to be considered by the regulatory norms. The document must be recorded in the tangible medium of short-term use, and paper. In this regard, it's not clear what kind of document the card is. And there are some certain documents which are might comply to the above-mentioned definition. The document has to be recorded on the long-term use medium, be it paper or plastic, well, any type of medium. Thus, we don't see clearly what kind of document is the bank card. It's neither a passport nor power of attorney. Who is the author of the document? What details are recorded indeed? So if the applicant fails to answer these questions, then it's very interesting to hear the ideas of the applicant, but unless this is provided, the conclusion that bank card is a document will be considered erroneous. But the very fact of emergence of such questions leads to the idea that the thesis is a rise in interest, and the thesis of Mikoni, Tatiana, on the topic protection of the bank's clients' rights in the transaction with the use of payment cards compliance with the regulations of 68/1 on the procedure for awarding the degrees of candidate in St. Petersburg State University. Tatiana Mikoni deserves to be awarded a degree of the candidate of legal sciences, and the procedure was not violated. Thank you very much for your positive review. Now the floor is given to Anatoly Vladimirovich Kostruby. Thank you very much for the opportunity to take part in the work of the Dissertation Council, and I would like to express my positive overview of the thesis. First of all, I would like to talk about the novelty and the functioning of the national monetary system requires the facilitation of the system so that it works in accordance with the rules and regulation of the market economy, which can be done only if we have a clear understanding of the payment settlements and is legally and has legal base. For a scientific base is the basis of settling any judicial matters. Legitimization is falling behind the legal aspects of payment procedure. Thus, a comprehensive research of the rights and responsibilities of the parties has to be conducted. The improvement of the respective mechanism of protection based on the comparison of different types of defense, both in our country and in foreign countries. The thesis itself provides a theoretic and practical base of the analysis of the cooperation of the client and the bank. The reliability of the summary can be proved by the articles published and the participation in the conference, and the systematic usage of theoretic and practical methods show the ground of the thesis. The practical importance of the obtained results might be used in legal and judicial aspects and for future research and education process. The object and the subject were determined along with the historic perspective, the analysis of the modern legislation regulating non-payment methods was possible, which allowed to see the ways of improving the legal base, which is in the balance of the process being easy and legally determined. Then there is the necessity to protect the rights of the judicial body, of the individual as a weak party. I highly praise the idea of the author to take into account the international aspect of the usage of payment cards. There is a necessity of the unification of the existing norms. The usage of payment cards is widely used, and there is a whole range of different agreements. And the legal base for the use of the bank cards is understandable. The judicial nature of the bank card and its role in the relationship with the clients. Based on the critical analysis and of different approaches, the author has well explained conclusions. Based on the agreements, based on the nature of the bank card. Because of the multifunctionality of bank cards, each conclusion is justified. As my colleagues have previously mentioned, each work might have not only the positive trait, but certain critical aspects which do not undermine the importance of the research, but only stress the author's approach to the specific issues. So certain aspects were of special interest to me, and I would like to express my personalized approach to some of the issues, and I will disagree with certain of the ideas. So I would like to pay your attention to the following remarks. Despite the fact that the topic of the dissertation involves disclosing the legal aspects of protecting the rights of bank customers when making payments using payment cards, the attention to this issue is, in my opinion, insignificant. Well, the theoretical model of the right protection is considered by the author through the construction of risk distribution between the parties of the agreement on the issue of payment card. The chosen approach to the research, in our opinion, limits the theoretical potential of the institution of protective of civil rights, which is presented in the work in an incomplete form. And some incompleteness of the work, which has an applied nature, is due to the absence of the judicial practice, which, in my opinion, would have improved this research. Also, it is debatable to see a bank card as legitimizing paper sign, as a legal document, the use of which legitimizes a person as a subject, following the order of which the bank isn't held responsible for illegal debiting the client's account and transfers fund. Taking into account the physical characteristics of the material of the carrier, it seems questionable to apply the term legitimation paper to payment card. The function of legitimizing sign is generally recognized, considering the implementation of the right expressed in it against its presentation to an obligated person. Regarding the payment card, it should be noted that its presentation carried out to another person who is not obligated under the concluded agreement on the issue of the payment card. Moreover, in order to carry out settlement operations using payment card, legitimation is not always necessary. Carrying out a settlement operation using the payment card can be only accompanied by the introduction of information that includes its number and the digital CVV or CVC code. Thus, a payment card is a technical function of access to the account. What is more, the author's approach to the idea of the nature of settlements using payment cards as an independent form of non-cash payments in the context of existing and normatively defined method of settlement using a payment order, which fully reflects, in our opinion, the respective requirements of the owner of the payment order. And the question arises, how does the author differentiate these categories, the payment card and the payment order? But the above mentioned remark are not linked to the concept of the thesis. In most cases are related to the debatable issues, and the thesis itself has a very positive overall opinion. The theoretical base and recommendations are of high quality. Finalizing my remarks, I'd like to say that the thesis by Tatiana Mikoni on the topic protection of the bank client's rights in the transactions with the use of payment cards is individual work with of high research quality and respect the requirements of the order by the 1st of September 2016, 6801/1, on awarding the degree of Candidate of Scientist of St. Petersburg State University. And Tatiana Mikoni deserves to be awarded the degree of the Candidate of Legal Sciences. And the Clause 11 is not violated. Thank you very much for your positive review. And now, dear colleagues, I would like to voice my review of the thesis. We can see that we have a certain discussion considering the thesis, and much time was dedicated to this piece of plastic, which I can find in my pocket. Well, about 20 years ago, when I was working in the savings bank, and I was the head of the judicial service of savings bank. At that time, we had the practice that when a person in a bank, the client, gets a bank card, the person bought this card for 1 ruble. There was a formal sale of plastic. Well, now the situation is much different, and the legal base and the paradigm have changed. But nevertheless, when we talk about payment order, we don't mean the piece of paper. For us, this is the information which can be found on the piece of paper, and based on this information, this specific piece of paper is of a certain importance. The same with the bank card. It is important because of the information which is encrypted in it, which can be found on it, and or using which we might be able to use our bank account. And I would like to pay your attention to the idea that using this information, we can access not only our account with the help of the plastic, so to say, this plastic form, but if we have the client bank or Apple Pay, then it also allows us to get the remote access to our account. So we talk not basically about the bank card as a piece of plastic or as a security, but the rights which we have when we possess this piece of plastic. And I would like to praise the idea that Tatiana Sergeevna wrote this issue and created the thesis based on this issue, and which resulted in discussion. The topic of the thesis is a novel, and the main aspect of the work is how to protect the rights of the clients of the bank who use the bank card as a way to preserve information. In this respect, this thesis is of scientific interest. In my review, you can see in details why I consider this thesis relevant and why the scientific conclusions are relevant and enough base. And I talked about the novelty of the provisions for defense. And overall, I have a very positive overview of the work. Nevertheless, I would like to set a number of issues. In the second provision, the author says that the loss of the bank card does not violate the cards, but it results in the fact that the process of obtaining is different, and it is important only if it is not burdensome for the client. Well, the very idea of it being burdensome for the client arises certain issues. Well, overall, I would like to agree with this idea, but it is not quite clear how to understand the burdensome for the client, because the card is the way of distance communication with the bank, and with its loss, there is technically no opportunity of such cooperation with the bank. Because we can use our smartphone or any other gadget to get the information on the bank card. But according to the bank rules, once I lost the bank card, I need to block it. Maybe it is better to create a legal or normative act, the basis for the limitation of the rights of clients on the account, not in accordance with the agreement, because this clear burdensomeness of the situation to the client, this is the area for the banks to create such terms and conditions for agreement and for the use of the card, which would be favorable for the bank and not for the client. Nevertheless, in my opinion, the thesis itself is well-grounded research, and the thesis protection of the bank client's right in the transaction with the use of payment cards corresponds to the regulations in accordance with the order of the 1st September 6801/1, and the applicant, Tatiana Mikoni, deserves to be awarded the scientific degree of candidate of legal scientist, a specialty 12, major 12/0003, civic business, family, and international private law. Clause 11 not violated. Well, dear colleagues, we have heard all the remarks of the members of the Dissertation Council and the Applicant now has the floor to provide answers to the above-mentioned remarks. The floor is yours. I have already answered some of the comments as a part of my opening speech, so I now will dwell more on the rest of the comments, since the fact that thesis and they have certain common ideas. I group them. So the first provision, legal nature of payment card is legitimate paper sign. I'd like to emphasize in the work such features of the card that determine the specifications of legal regulations and have the crucial importance for legitimizing function of the payment card. This is why we stress the legitimizing function of the card. It is not the only function of the card, but in our opinion, it's one of the key functions. I cannot agree with the idea that it is used not only for this function, but this is a technical device for processing the information, and this is definitely an electronic way of payment. That's why all the norms and regulations, characteristics of a payment card as a technical device are attributed to it. But these functions do not determine the specification of the basic card, but the process, but the opportunity to legitimize the client as a person inherent in a payment card. Thus, the compliance with the agreement is maintained. Card readers and ATMs and other technical gadgets are important for getting the information from the bank. The bank card is a thing. It is an object of the material world which has boundaries and space, and since it's a thing, it must have an owner. And banks are now categorical in determining who is the owner of the payment card, and it is a property of the bank, and it's often stated that it must be returned to the bank after expiration dates. Well, it is not effective in practice. And the bank cards are not usually returned, but the banks say that the client has to demolish the card. The bank is not interested in physically getting the card back, but however, the contract retained the condition that the card must be destroyed. So the bank, as the owner, disposes of its property as it wishes. Payment card is a document. We can see that we don't, in the federal law on obligatory copy of documents, the material copy doesn't matter as long as it's capable of storing and transmitting information. And if we say that the author is the person who determines the content of the information on the card, then this is the issuing bank. It determines the information on the card in accordance with the payment system. The sign of a legal document that distinguishes it from other types of documents is that its contents certify certain legally significant facts or legal relations based on them. The payment card confirms the existence of the legal relationship between the bank, the card holder, and the bank, and determines the client as a proper creditor in the legal relationship. There are certain requirements for the content of any legal document, and the lack of certain information can be different and depend on the function of the document. The amount of information contained on the payment card is determined by the bank, as I have already said, in accordance with the rules of the payment system. Thus, the structure of the information is also determined. The payment card contains several types of information, and it's recorded in several forms. In the form embossed or applied in the form of a trademark in electronic form, as a magnetic stripe, recording, or embedded microcircuit. The absence of certain information on the pay card can lead to the impossibility of legitimizing the creditor of the payer, thus the impossibility of conducting the operation. Documents for which legitimation function is major got the name legitimizing security or sign. Both terms mean the same and can be used interchangeably. So to simplify the perception, I will continue to use the term legitimation mark. Legitimation mark is a term which is traditionally used to refer to the legal documents of unilateral legitimation value for the benefit of the debtor. The main difference from the security is that they are not they are legitimizing values for the benefit of the debtor, and they whereas valuable papers or securities have bilateral value. Unlike securities, these signs do not distinguish objects of civil rights into special group. The characterization of a thing as a legitimate mark describes certain properties of a thing that cause legal consequences. So legitimate signs do not form a specific group of objects of civil rights, but there are certain characteristics of the documents which have certain legal properties. Thus, special regulation might be in place. Legitimate signs are widespread in everyday life. For example, train tickets, theater tickets. The fact that the presentation of payment card is often carried out not directly to the issuing bank or not directly through the ATM belonging to it is not an obstacle to the payment card serving as a legitimate function. Thus, the trade organization or acquiring bank, the ATM of which is used, acts as a third party involved by the issuing bank to fulfill its obligation to the client. In fact, the similar situation could be seen when a theater has a certain agreement with the worker who is responsible for checking the ticket, and thus legitimizing function is important for the debtor, that is for the bank. Another specific trait of legitimate marks is that, unlike security, their presentation is not obligatory. Thus, the legitimized sign might be presented or not presented, and the rights remain unchanged. So the opportunity to have settlement without the payment card does not contradict to the definition. Another feature is the ability to transfer the payment card to the third party. It makes no sense to allow to prohibit cardholders to transfer or to give the cards to the third parties. Well, indeed, it's very difficult to find out whether it was true that the bank card was given to the third party. And the bank will follow its obligations, whether the card was presented by the card holder or the third party. There is no unified agreement on the issue and use of payment card. This is an agreement construct just like an agreement for the benefit of the third party. So these documents might be similar to this type of the document. There might be several types of agreement. This is account agreement, including of the crediting account loan agreement and the use of electronic money, for example. So the type of agreement determines the type of card that can be issued for such an agreement. Payment card is issued on the basis of the bank account agreement, which may contain elements of loans agreement. So the loss of the card does not lead to the loss of its rights by the holder. The prohibition to carry out a transaction on the account without a card is limitation of the client's right to manage funds on the account. This general rules the right of the client to dispose of funds at his own discretion without restriction, according to the Article 845 of the Civil Code. However, the same article states that the restriction on the client's right to dispose of funds on the account are allowed in cases provided not only in the law but also in the bank account. Any restriction of the rights of the client in order of cash must be justified by need to protect the public interest and the interest of the third. Thus, it's difficult to disagree with the fact that it's better to establish in the law, not in the contract, the grounds for limitation of these rights. This is the approach proposed in the concept. But this idea was not supported by the legislature. So now the Article 845 states that such restrictions might be provided by the agreement. If there is such a rule in the law, then it creates a mechanism of exposed to control the fairness of such limitation access. The Civil Code has a corresponding norm in Article 428, and they would see the mechanism of the justification of agreement concept. Thus, we will be able to include clarity into such a complex as obvious burden for the party. In the absence of such a mechanism, each type will be necessary to supplement the law with new prohibitions and to provide certain conditions in the agreement. But the banks are professional subjects and they will find new formulations in order to bypass the prohibitions in the law. Thus, the mechanism will be simply inefficient. So it's necessary to change the attitude to the Article 428 of the Civil Code. The next thesis, the novelty of which arose certain doubts, concerned the fact the moment of fulfillment of the monetary obligation and settlements using payment card at the moment of crediting the funds of the corresponding account of the creditor's bank opened in the settlement center of the payment system within which the settlement is carried out. There is no unified law that would determine the general rule on the moment of termination of a monetary obligation for all form of non-cash payment. In the Article 316 of the Civil Code, there is information dedicated to the place of termination of the obligation, only related to electronic monetary funds. So it might be applied only to prepaid cards. The idea was to create a unified rule for all cases, for all types of settlements with the use of all types of cards and not only prepaid cards. In the loss provision for defense, and much is dedicated to the mechanism of distribution of losses between the bank and the client, but nevertheless, the thesis pays a lot of attention to the information obligations of the bank at the process of protection of the information of the client and the mechanism of protection of rights of clients with the help of exposed control of the fairness of contractual conditions provided by Article 428 of the Civil Code. So on the whole, not only the allocation of distribution of losses is considered as the only mechanism, but also other mechanisms should be taken into account. The monitoring of judicial practice was carried out, and all cases relevant to the topics were studied in much detail. And the list of references contains link to 36 court cases, but definitely this is not all the judicial practice that was analyzed. But in most cases, judicial acts repeat each other in form of text. For example, on page 120 of the thesis, it is indicated in practice that the synchron between liability and risk sharing is often ignored, and there is reference to several judicial acts. Unfortunately, there are hundreds of similar acts, and this is a system problem that the courts misunderstand the Article 9 of the Code of the National Payment System. The similar situation is with Article 428. There is only a couple of references to the judicial acts, but there are hundreds of acts. Well, I suppose that this is all, and I'm ready to answer any further questions, if any. Dear colleagues and members of the Dissertation Council, is everybody satisfied with the answers of Tatiana and Mikoni? Well, everybody's satisfied. I have no questions, but I would like to express the gratitude for the lecture on legitimation signs, following the questions of the members of the Dissertation Council. Yes, you could be more concise. We heard the gratitude, and it will be put into the minutes and will be left in the archive of university. Now we move to the next stage of the defense. Those present might participate in the open discussion. Is anybody willing to take the floor? There's nobody willing to take the floor. Then we move on to the next stage. And these are the questions that were submitted via the internet. Were there any questions submitted? No questions were submitted via email. In such a case, since there are no questions, we move on. And we give the floor to Natalia Yurievna. Concise, within 3 minutes. Give us information on the applicant, the work, and positive traits. I try to be very concise. The applicant is a great researcher, conducted well-grounded research, and throughout the research became a great lecturer, and used the result of the research not only in the articles but within the process of the lecturing. And I would like to appraise her. I would like to thank the colleagues, sincerely thank the colleagues for the comments that they have expressed today. It's very interesting. Certain aspects left me with certain ideas, and I think that the applicant further on will also consider all your remarks and comments and make her conclusions more grounded. Thank you, colleagues, for your time and for your effort. And I thank Anatoly Vladimirovich as our most distant participant. You're now in Ivano-Frankivsk, as far as I understand. Let this pleasant communication remain with us. Lyudmila Georgievna, I'd like to welcome you. We've known each other for many years, and I'm very grateful to you for your participation in this council. And I hope that we will be able to communicate even further. And I would also like to thank my dear colleagues from the university. Thank you very much for your participation. I yield the floor. Thank you very much. That was Tatiana Sergeevna, the research advisor. Since we conduct our meeting with the members who are in a remote access mode, my question is, do the members of the Dissertation Council have any questions, or the applicant itself having any questions which remained unanswered? If there are any questions, please ask them. Since there are no questions, I address the members of the Dissertation Council. Before we start the roll call, we might be able to announce the break in order to discuss the results of the defense with the muted sound. And we might discuss certain issues, if any, in the closed mode, so to say. How do you think? Do we need such a break to discuss the results, or we might proceed since everything is clear and there is no necessity to announce a break? No, there is no need. I think there is no need. Yes, I understand everything. I support the ideas of my colleagues. No, there is no necessity in having the break. The technical part was at high quality. The reviews can be found at the website, and in my understanding, there is complete clarity. Then we proceed. We move on to the voting procedure. The opinion of each member of the Dissertation Council is voiced separately. So I put the question of awarding to Mikoni Tatiana Sergeevna scientific degree of the candidate of legal scientist on the scientific major 1203 Civil Law, Business Law, Family Law, International Foreign Right, to open roll call. I reminded you that the decision of the Dissertation Council that the issue of awarding the academic degree considered positive by more than half, at least 3 members of the Dissertation Council who participated in the meeting voted for it in accordance with the clause 23 of the procedure. Now I will personally address each member of the Dissertation Council. Alexey Alexandrovich Gorovdov, please, your opinion. Tatiana Sergeevna deserves to be awarded the scientific degree of the candidate of legal sciences. Vladimir Fedorov Papadopoulos, your idea? I'm for. Thank you. Lyudmila Georgievna Yefimova, your opinion, please. I'm for against, and I consider Mikoni Tatiana Sergeevna to be awarded the candidate of sciences. Anatoly Vladimirovich, I support my colleagues and I vote for. Thank you very much. And I, the head of the Dissertation Council, consider the fact that Mikoni Tatiana Sergeevna deserves to be awarded the scientific degree of the candidate of legal sciences. Dear colleagues, out of 5 participants of the voting, 5 voted for, Against? None. Abstain? None. The decision to award Mikoni Tatiana Sergeevna the scientific degree of the Candidate of Legal Sciences on the scientific major 1203 Civil Law, Business Law, Family Law, International Private Law accepted. Dear colleagues, due to the fact that our meeting is held with participants of the meeting in the remote access mode, to the members of the Dissertation Council or the applicant and other attendees, any questions, comments on the procedure of the meeting? Alik Alexandrovich, do you have comments? No comments. Vladimir Alexandrovich, no comments. Lyudmila Georgievna, no comments. Antal Vladimirovich, no comments. Thank you. Thank you very much. And the final word of the applicant. The floor is yours. Be concise. I'd like to say thank you very much, all the members of the Dissertation Council, for participating in the Dissertation Council, for dedicating your time to this thesis, for your remarks and for your questions. And I'd like to thank my scientific advisor, Natalia Yurievna, for her help and for a great amount of time that was dedicated to me and to my thesis. I'd like to thank all my relatives, my parents and my family, and the university and my department. Everybody supported me and my department at State University. Thank you very much. We congratulate the applicant with applause. The meeting is closed. Thank you all for the participation. Please turn off the live broadcast of the meeting. But